SJC-13514, Holly T. Freiner, personal representative of the estate of Costa Tingos, v. Secretary of Health and Human Services.
Okay, Attorney Knudsen, whenever you're ready.
May it please the court. Jamie Knudsen on behalf of the appellant, the estate of Costa Tingos. Congress and the Office of Medicaid's considered view is that the institutionalized spouse, when applying for mass health, if they sign their rights to spousal support to mass health, that is mass health's remedy as it relates to mass health considering the resources of the community spouse. And this really just reflects the fact that the applicant is the person applying for mass health. The spouse is really not the applicant. Now, the applicant has a duty for, in this case, himself, to provide all the information he has. So if they've if they shared their financial information during their marriage and he can provide that, he absolutely has that responsibility. This appeal has nothing to do with that. There's no dispute in this case that Mr. Tingos assigned his rights of support to mass health. There's no dispute.
It's patent or latent that there's more money here, and he's only provided what he knows, but she's the prime earner. She has his power of attorney. He's lived with her for 50 years. They have a right to probe further. And she's not like a spouse who's run away, and so why isn't their rule reasonable? Why isn't this reasonable that we need to find out whether there are more assets here, and your client didn't do enough, why isn't it reasonable?
Well, Your Honor, there was a lot of probing since 2015 as we had 3 fair hearings and 3 Superior Court appeals. And he did supply, and the reason why in this case, Mass Health knows, they've extrapolated, it's in their brief, it's in all their briefs. They know Mrs. Tingos had probably a couple $100,000. They're extracting that from the tax records that my client provided. So they have that information.
And she's his power of attorney. And she's, the rule you seem to be pushing for, to me, would invite every single, everyone could do this. We basically say, oh, I'm not cooperating, and therefore the state will take on the burden of this instead of, again, the state is stepping in when you're desperate. It's not supposed to be stepping in when you have resources. I just don't see how what you're pushing for wouldn't create a rule where everyone's going to do this.
Well, Your Honor, the statute and the regulation have been in place for a long time.
Well, maybe your lawyering is more creative than people in the past. And you're inviting something that's highly problematic and maybe exactly why we should have this rule.
Well, Your Honor, it is not my rule, okay? And it is not even my creative lawyering. This is the statute. This is the federal statute.
Let's get down to the statute. The statute says that you have to disclose the institutionalized spouse must disclose all the assets of the institutionalized spouse, the marital assets, and the community spouse, right? And that's when assignment is sufficient. In the absence of the disclosure, which as I understand it is the case here, assigning is insufficient. And that makes a lot of sense. Because if Mass Health is told precisely the resources that are available to pursue the community spouse for spousal support, then it need not waste resources, and it can do a cost-benefit analysis on whether or not it can expect to get some of the money back.
But, so first is that in the federal statute, and I do think it's important, we're going to need to talk about the federal statute and the state regulation, because the state regulation.
Well, let's start with the federal statute where you're
Okay.
starting. Go
But
ahead.
with the federal statute, is that there's nothing that says Mass Health needs to be able to do a cost-benefit analysis. It says if the institutionalized spouse assigns the support rights.
Well,
Through
it
that-
says the institutionalized spouse shall not be ineligible by reason of resources determined under paragraph 2, which are the 3 sets of resources that I just delineated.
Yes,
And here, the 3rd set, the community spouses assets, have not been disclosed.
and that's because the applicant doesn't have the information.
Right, and so quite nicely, Mass Health has a separate regulation that deals with that scenario.
Right. And I would say, assigning the right of support gives Mass Health the ability to get that information. In other words, the discovery process in the complaint for support. They have the ability to get the resources that are
But if there's
determined.
nothing there, why start the suit? That's why I don't understand. Now, Mass Health's position seems eminently reasonable. Let us know what the pool of money is, and then we can start the discovery process and pursue the community spouse. In the absence of that information, it's a gamble on the people's dime.
But that is Congress's determination.
But that's why I taught you, went back to the words of the statute. Congress's determination is that the institutionalized spouse shall not be ineligible by reason of the 3 sets of resources disclosed by the institutionalized spouse. And here, there hasn't been that disclosure.
Well, there has been that disclosure to the extent that Mass Health knows because, and they've put it in their briefs, they understand it because it was in the tax records. They don't know exactly how much, but they know it was hundreds of thousands of dollars. They did their own extrapolation. They said at a minimum it's 110,000. It might be as much as 366,000 based on the tax records that we provided. So they aren't in the dark about that in this case.
But they don't know Justice Wendland's question is, they don't know the resources determined to be available without more cooperation, right? You know.
Right, but they have the right of the spousal support action. There's no, to just say that's meaningless, which is what Mass Health is trying to do.
I think they're saying it's meaningless. Yes, they can sue and, start chasing, but again, they don't know, as Justice Wendland said, whether there's anything there. By doing it up front, one, they're creating leverage to make sure they know all the resources determined. So it just seems like a reasonable gap filling of the federal language.
Well, Your Honor, so we can talk about the federal statute in the sense that it doesn't explicitly address what happens if a spouse refuses to provide their financial information. But Mass Health has had a regulation for a long time which specifically addresses this. And I do think it's important, Your Honor, that this is the language of prohibition, which this court has acknowledged in Mason and other cases. Said that that the institutionalized spouse shall not be ineligible for benefits. So in reading the regulation, an institutionalized spouse whose community spouse refuses to cooperate will not be ineligible due to his or her inability to provide information concerning the assets of the community spouse when one of the following conditions exists.
Right, so that begs the question of what it means to refuse to cooperate. Is it refuse to cooperate in providing the financials that are required by the federal statute? Or is it a greater act? And I'd like to give you an opportunity to address that.
Well, I think the regulation is clear in that it connects in those sentences the community spouse refuses to cooperate, and as a result of that, has the inability to provide the financial information. So it's the community
Well, that's
spouse.
one of the results. So you're saying refusing to cooperate means the inability of obtaining financial information from the community spouse.
Yes, that connection is there in the regulation itself.
But that refusal to cooperate language is in the preamble of the regulation, 51711, right?
No.
Yeah, it says an institutionalized spouse whose community spouse refuses to cooperate. And then it has section A that says assets determined to be available.
Right.
That's the
Or-
comparable of the federal statute, right? Section A.
Correct. But then, or, not, clearly not and, or B, his or her inability to provide the information concerning the assets of the community spouse. So the refusal to cooperate is in the context of this Mass Health application and results in the inability to provide the information.
Right, it results in the inability to provide the information, but it also applies to when the information is available, right?
That absolutely.
Okay, so it can't be limited to the situation where the community spouse doesn't provide the information.
Correct. And so spouses could, right? So a spouse could provide a community spouse, I should say, again, who is not the applicant, could decide, I'm going to provide all this information, and then just say, I'm not going to actually make any of my resources available to the institutionalized spouse. And Mass Health has its remedy through the assignment of support rights. So, and I know there's a number, it's been referenced here, it's been referenced certainly in Mass Health's brief, it's been referenced in a number of cases, that the fact that this is a program for the needy is why there shouldn't be rules that allow wealthy people, I mean, just to be clear, right? Because that's not what these resources are devoted for. But this is not that case. This is a revenue neutral case for Mass Health because they have the rights of support.
Well, it's not really revenue neutral, right? Because the way you want to interpret it is the community spouse is going to get free nursing care, free nursing home care, whatever, right? It's going to, even though these people are wealthy, in my hypothetical, maybe not your case, even though they're wealthy, that community, the institutionalized spouse will start getting care right away, right?
Yes.
And then they've got to sue the wealthy spouse. So that's not revenue. It may work out that way a couple of years later, but it's different, right? That's why having that leverage up front changes the dynamic. That you're paying for that care until you get to the next step, right?
Yes, but they can bring a complaint for spousal support.
A wealthy person is going to be receiving, again, in my hypothetical, not yours, and under your wealthy people are very good about that. So how does that make sense, given this is a statute for the poor and people without assets, right?
Because Congress and the Office of Medicaid has said that this is Mass Health's remedy to deal with this situation.
Well, only if we interpret the statute in the regulation in the way that you're suggesting. In the way that Mass Health is suggesting an interpretation, it doesn't have that perverse outcome that Justice Kafka is talking about.
Well,
Why is that unreasonable?
I would say I'm not interpreting the statute. The statute. So it is undisputed in this case that Mrs. Tingos did not cooperate by providing her financial information. Mass Health is merely making a public policy statement and preaching a sermon to Mrs. Tingos, and I'm not exaggerating that in the fair hearing officer's hearing, that their argument is if you're married and you've gotten any mutual benefit out of this marriage, and they're really saying it to Mrs. Tingos, those spouses must cooperate. That is completely against the statute. And I will say this.
Your best argument is that they're artfully changing refuses to cooperate, because your community spouse here is not cooperating in your view. In plain language, she's refusing to turn over the goods, and they're sort of ignoring that. That's your best argument, right? That I don't follow your federal argument very well, because of what Justice Wendland points out is it assumes that the assets are disclosed, but Mass Health is changing somewhat the meaning of refuses to cooperate, at least from its natural meaning, right?
Absolutely. And again, I will say at the second fair hearing, the hearing officer found that Mrs. Tingos had refused to cooperate. Mass Health essentially admits it in the brief. She has refused to cooperate by providing her financial assets. And by the way, it is worth reading the affidavit from Mrs. Tingos which were part of the analysis of the hearing officer. This is extensive as to exactly why their assets were separate. They weren't just separated right before the application. This is not some created defense. He had a serious gambling and addiction problem, according to her. None of that is disputed. And they filed joint tax returns. And because he was paralyzed, she had to act as his power of attorney to write bills and to deal with things.
Did she actually do the application?
Absolutely not, Your
Oh,
Honor.
okay, that was
and
what
that
I
is
was
all
wondering.
in the record. Mr. Tingos did the application, testified at the hearings, did everything, did his own efforts regarding all of that. I know that my time is out. I would ask the court to reverse the judgment and order Mass Health not to deem Mr. Tingos ineligible because of Mrs. Tingos' refusal to cooperate.
Thank you. Attorney Bolanos.
Good morning. May it please the court. Assistant Attorney General Cassandra Bolaños for Mass Health. I'd first like to address the interpretation of refusal to cooperate in the regulation. The regulation does not precisely spell out what refusal to cooperate means. And so this is certainly a case where
It does seem like she's refusing to cooperate, right? You're basically saying an institutional spouse whose community spouse could cooperate and doesn't will not be ineligible due to, right? I mean, I understand the practical consequences that everyone's going to not cooperate unless you dig deeper into that. But it is hard to say that this is, the community spouse here is refusing to cooperate. I mean, she is refusing to cooperate.
she's refusing to cooperate on the Mass Health application or with Mass Health, but it's an eminently reasonable and natural reading to read this as a community spouse who refuses to cooperate with the institutionalized spouse. And the record doesn't support a lack of cooperation.
Walk me, so let's read through the regulation. An institutionalized spouse whose community spouse refuses to cooperate or whose whereabouts is unknown will not be ineligible due to his or her inability to provide information concerning the assets. Isn't the cooperation related to the assets? I mean, it's sort of a normal reading. Again, I see the practical problems and.
Right. Well, his or her inability to provide information, conceptually, where the spouse is not cooperating with the institutionalized spouse, that's what prevents him from providing the information to Mass Health. And here there wasn't evidence of non-cooperation as between the two spouses, where Mr. Tingos testified at the second fair hearing that he's never asked her for this information and he's never discussed her refusal.
You know, Mass Health is not looking at their marriage as a whole, right? He wasn't a cooperative spouse, or she wasn't a cooperative spouse. She was a difficult spouse. That's not what we're really looking at, right? We're really looking at cooperation in this process, right?
It can't just be reasonably construed as cooperation in this process, because that then permits a spouse to cooperate up until the point of the application and then to opt out of the eligibility requirements.
Right, that's the problem, which is everybody's going to do this. If you can take care of your spouse up until the day where you can dump the spouse with,
Right.
they're all going to and keep your money. No one's going to do this.
There's no limiting principle to the appellant's interpretation of this language.
He's saying, go chase them then. You know, just when you got that kind of sort of slick behavior, go sue them. And I take it you could do that, right?
Well, so one, it contravenes the federal and state mandate that Mass Health is a payer of last resort. So it turns the regulatory and legislative design on its head.
Up front it does, right? I mean, meaning that you have to start paying them until you can
Right.
identify the assets and I
Right.
get it, but I take it you could pay yourself back. And
It depends. Even I'm not sure where it is in the record where Mass Health estimated that her assets are worth 110 to 360K, but that actually makes a material difference because in 2024, the community spouse resource allowance is $154,000. So in that case, they'd pursue litigation on taxpayers' dime and wouldn't be able to recoup anything. If it's 360, they would be able to recoup something. And, you know, I don't think that, I'm not an expert in family law, but I don't think that the remedy is the panacea that appellant says it is. This would be Mass Health stepping into Mr. Tingos's shoes, saying that there is a grounds for spousal support of a married individual. And, you know, I did some search, and the provision that I found that
oh, you must. I mean, it's a federal statute. You must have the power to chase this money, right? I mean,
well, CMS guidance on the federal provision, which I think the court agrees does not apply to the situation because it presumes that assets have already been disclosed, says that what support rights are available is a question of state law. And here, spousal support and alimony is a creature of statute, and it's limited by statute. And so the provision that I found that would most likely apply is Section 32 of Chapter 209, which provides for...
You're not questioning your ability to pursue this, right?
Well, I'm certainly not saying that Mass Health has no available remedy, but Mass Health would be in a position to, establish grounds for spousal support, and in some cases it does require establishing marital offenses such as abandonment or, showing justifiable cause to live separately, and that's not what we have here. We have quite the opposite. It seems that Mrs. Tingos largely supported Mr. Tingos financially and in the home that she owned up until he went into nursing home care. So this is not, that's why the exception is construed reasonably and narrowly to really capture those situations where the information and the resources of the community spouse are legitimately not available to the institutionalized spouse. And
so just to close the loop on refuse to cooperate, so you ask us to read an institutionalized spouse whose community spouse refuses to cooperate with what? What is the language that's implicit in that, just for us? So when we write this up your way, if we do so, how are we going to, what missing words are we putting in there to make this make sense?
I think it is a refusal to cooperate between the spouses. It can't just be the spouses associate together for mutual benefit for many years, and then there is this discrete lack of cooperation on the application with Mass Health.
So that tells us how not to define it, right? Refuses to cooperate is not when the sole act of non-cooperation is the failure to disclose the community spouse's financials.
Right.
Right. So how do we affirmatively respond to or define refuses to cooperate?
I don't think that that this can be categorical. I think Mass Health and the board in particular has interpreted it reasonably based on a fact-specific application. And I can give examples of other board decisions where they have found that the exception applies to show how it varies based on the facts. But in one case at Record Volume 5, pages 4 to 7, the couple lived separately for 21 years, filed separate tax returns, and maintained, quote, separate finances, assets, households, and lives. In the decision that follows it, the board found that the applicant and community spouse were estranged and maintained separate households. In another case that was a little different, the applicant herself lacked capacity to obtain the information due to dementia. The community spouse also had also suffered from some cognitive issues, and he had moved out of state, so you have closer to a case of abandonment. But what the application of this refusal to cooperate language is capturing is where the resources are legitimately not available to the institutionalized spouse, such that
How does this, if we say refuses to cooperate is something akin to what the examples you've delineated, how does that square with the federal statute to which Mass Health needs to comply? Right, in the federal statute, if the community spouse discloses the assets, then a simple assignment is sufficient. It seems like Mass Health is adding an extra layer on top of that.
it's adding a layer on top of it for the failure to disclose.
No, it's not actually. I mean, if you look at the regulation, that does come at the preamble of both sections A and B. So refuses to cooperate is part of Section A, which is the comparable to the federal statute.
That's right.
And so how does that, I guess, how do we deal with that? Mass Health, as a state agency, is adding an element that is absent in the federal statute.
Certainly subsection A, as you know, is not at issue in this case, but
No, but it is in that the preamble applies to both A and B. And if we interpreted the preamble the way
Right.
you suggest, it affects A.
Right. I'd say in the scenario of A, where there's a clear federal provision that says shall not be ineligible where the resources have been determined, where there's an assignment of rights, Mass Health would comply with the language of the federal provision, and I've confirmed that that's their policy.
Where the regulation needs to be rewritten, because in effect, what the state agency has done is undermine the federal program that Congress had in mind under the MCCA.
Certainly not as to subsection B,
Right.
because B
So
preserves.
if the preamble came before subsection B or was embedded in subsection B, I think you're right. I mean, I think the problem is that the regulation as written makes A subject to that refusal to cooperate. And it's not something that's been briefed. And with the permission of the chief, if that's something that you can address in a 16L letter, that would be great.
Yes.
In addition, I noticed that subsections 1, 2, and 3 only seem to apply to subsection B. So, I mean, it seems like the whole regulation was not, there's some sort of error in the regulation, because at least if you look at A, all that needs to be done is that there's a determination of all of the assets of the couple without an assignment.
Right. Right.
Which is not
Which is not the
federal
intention. I'd say that error is more akin to Scrivener's errors, but I acknowledge the difficulty there.
Right, it seems like there's a few in the regulation, so it would be great if you could address how we resolve that.
Yeah.
Because we don't usually rewrite statutes and regulations.
Right.
Right.
I understand.
But can you read the refusal to cooperate? The feds contemplate the disclosure of the assets. And can you read the refusal to cooperate as not being inconsistent with it, but sort of explaining a situation of why you don't know the assets? So it's consistent with the, I don't see them as being necessarily inconsistent. I see them as, although they're not saying the exact same thing, but the feds assume that you've determined the assets and then they allow you to go chase them. But here, you can't determine the assets because the spouse is not providing the financial information you need. So I don't know if that was a question or a mulling, but.
Right. Here, and that's why the federal provision does not contemplate or apply at all to this situation because the entire federal scheme presumes full disclosure. There's no exception whatsoever in the federal law for a failure to disclose or cooperate in the application process. It's something that state Medicaid agencies who are on the ground implementing this program have confronted, and many of them have adopted an approach similar to that of Mass Health.
And do many of them use this refusal to cooperate language, or do they have their own better articulation of this?
Certainly, a lot of states actually have narrower exceptions than Mass Health, but a lot of them do use refusal to cooperate, including Delaware, where they say that they must consider all assets unless the couple has been separated and in two households for at least 12 months preceding the need for nursing home care, and the community spouse is uncooperative or his whereabouts are unknown, and that's Delaware Regulation 5100-2900. Connecticut also permits an assignment of support rights only if the institutionalized person cannot locate the community spouse or the community spouse is unable to provide information concerning his or her assets. So there it's narrower.
What's the comparable state statute for 51711?
The comparable state, this is just a regulation. I don't think there's a statute that has this exception. Of course, 520.016 is and that's the regulation that implements the federal scheme for determining eligibility for institutionalized spouses. I'd also like to mention that appellant's interpretation would undermine the main purpose of the MCCA that enacted this entire regulatory scheme, because Congress was trying to ensure that couples with sufficient means contributed their fair share towards long-term care costs, and that assets weren't sheltered with the community spouse. Because before the MCCA was enacted, most states only considered jointly held assets, and so this permitted states, couples with ample means to shelter assets with a community spouse, and this appellant's interpretation of this regulation would essentially open up that loophole.
But can I ask you, Chief, with your permission, why that? I don't understand that argument, because it seems like the federal statute just contemplates disclosure. And if and once disclosed, the state agency can say, aha, it's worthwhile going after Mrs. Tingus in this case because she has sufficient assets. It still allows the sheltering of the assets. It just requires that those sheltered assets be disclosed, and it's up to the agency to go after them.
Right, but here the sheltering happens before the state even knows what's there, and so there's extra cost to figuring it out and determining whether or not.
Right. No, I agree with you that the state regulation is dealing with a situation that the federal Congress didn't deal with. But your argument, I thought, was that this would undermine Congress's purpose. And my response was, I don't really understand that, because Congress's purpose is just, okay, you want to go shelter, but at least tell us what the assets are.
But this takes it even further, where everyone could essentially just opt out, forget about the community resource allowance, forget about that intricate formula and process, and you opt out at an earlier phase where there's just no disclosure and the state agency doesn't know what's on the table. We'd ask this court to affirm this was Mass Health has reasonably interpreted its own regulation. That regulation was applied appropriately to the facts of this case. Thank you.